Tonight, the High Court has struck a major blow to the Building Bridges Initiative Constitution Amendment Bill 2020. That process after it ruled that the exercise was unlawful and unconstitutional. The court, in a unanimous decision, took apart the BBI Constitution Amendment Bill and proceeded to deliver a blow-by-blow expose on what it deemed as illegalities of both substance and process around the constitutional change push. The landmark ruling that lasted over 5 hours has effectively derailed constitutional change process, or if you like, reggae, has been stopped. Well, at least for now, because tonight on Crossfire, we seek to make sense of these latest developments, what they mean for you and as a country as well. And as I said, reggae has been stopped, but for now, at least, what we are understanding, news just coming in because the court session is still ongoing. The Attorney General seeking stay orders on those directives that have been announced by the 5-judge bench. Over 5 hours, huge issues that have emerged from that. One of them, that the President of the Republic of Kenya, Uhuru Kenyatta, was been found to have failed the leadership and integrity test, that he violated Article 131 and failed to respect, uphold and safeguard the Constitution, that Uhuru contravened Chapter 6 of the Constitution, and numerous other issues that have emerged from that. I have my guest with me tonight here in studio to just try and make sense of what we've just been following the last couple of hours. William Kabogo is a former governor of Kiambu County. We have TJ Kajwang, who's a newly elected, would I say, or appointed vice chair? Elected of the Justice and Legal Affairs Committee, also member of Parliament Ruaraka, and Khalwale, former Senator Kakamega County, the bullfighter. I saw you do a jig a little bit earlier before we went on air as you were listening to what was happening. What do you make of all of this?
It's good news. It's good news not because of what the courts have said, but because everybody is a Kenyan. And people were tired. They were tired of hearing BBI amendments, BBI signature collections, BBI in the county assemblies, BBI in the Senate, BBI in the National Assembly, and BBI referendum. At least the courts have spoken for all of us who are not big people like TJ Kajwang, who have a platform from which what you say is recorded with the possibility of it being acted on. But having said that, this is time for the President of the Republic of Kenya, who is very well known to all of us, and who I hope might find time to listen to what we are saying, for him to do a bit of soul searching. Same to Raila Odinga. Why are they forcing so much? Why? Some of the things the court has said, no one would ever have dreamt of them. I happen to know some of the background of the petitions in court. The reliefs we have been given are as many as almost 17. I would not have expected that degree of success. The fact that this has happened, let them sit back, take a deep breath, and do the following, to my mind.
All right.
One, they can choose just to abandon it.
They're already looking to stay.
Number two, they can choose to continue fighting the way they are doing, asking for stay with the eventuality of appealing in the Court of Appeal and eventually Supreme Court. But if they want to win the hearts of Kenyans, there are two options. They should say, we are well advised by the court. We are either going to relaunch the exercise because it was in good faith as a proper people initiative, or as a proper parliamentary initiative. Big
blow, TJ, huge blow. Is there anything you agree with listening to that ruling?
Well, Sophie, good evening.
Good evening.
I listened to Senator here. In a sentence, he said, the reliefs we sought, we only got, I think, 8 out of something. But what I was looking for is the word we. Now we know who sponsored the plaintiffs in this case. It's not hard to see where this was coming from. But let me tell you, there is nothing to celebrate, and there's nothing to be excited about in the ruling that we have just had.
But it's huge.
I know.
It's huge.
Yes, it is huge. In fact, it is the momentousness of that ruling that should make us shudder and be sad, because it is a loss for the country. Some of us had the audacity to suggest to Kenyans how to fix this economy, how to fix the country. We are all Kenyans, and socio-economic organizations is a marketplace for ideas. At least we were brave enough to suggest exactly how to fix the problems we have heard before. This ruling is a big blow to devolution. It's a big blow for those people who thought that they will get health facilities, roads done by the county governments because more money would come down. This ruling is a big blow for us who are progressive Democrats, who thought that we now are suggesting a method by which we can fix this continuous rancor and fighting at the end of every election.
How about restart it afresh and do it right, because it's process that has largely
well,
been
it is
questioned.
really not about restarting.
Because the
I'll tell you this.
president had
you
no
should
business.
ask me what do we want to think, what we think about this.
Okay.
That should be the right question. First, I'll tell you, we are not going to be personal about this. We are going to be as wholesome as we can. Of course, the promoters will give us instructions exactly what they want. Some of them may wish that we take appeal. We are going to absorb that ruling and advise them properly. But the question is not to be personal. The question is not to feel like we have lost. And so if we come to that decision, probably, we may even come to the decision that we have given enough suggestions to Kenyans, enough for them to go forward and do what they must do in the next general election, and after the general election, fix it up.
All right.
Honorable
Kabogo, your thoughts on this? I wonder, have you considered where the president, what he'd be thinking right now after seeing...
My worry is not what the president is thinking right now. First and foremost, Kenya is a country that believes in the rule of law.
Yes.
So they have pronounced themselves, the judges. If that decision is not stayed, then that becomes a decision within the rule of law. Whether there are people celebrating or not, that is the position as it is. Unless remedy is found through the same process, I would say BBI reggae has stopped for the time being. There are benefits that were in the proposed BBI that would have been really good for, as TJ has said. One, for constituencies that are overpopulated, who are expecting that more money would flow into devolution, and therefore more speedy development. So my question is, as a country, can we find a way of getting those benefits in the shortest time possible? Because you will find there are counties that are stuck because they cannot do any development because of the monies they have. Kakamega, Kiambu, Mombasa, Nairobi. The inequity in terms of resource distribution is one thing that that proposed bill was sorting. But having said that, where are we? We are in a situation where they have said it is unconstitutional, it is illegal, and
null and void.
Null and void, unless the same process, because, for example, if the bullfighter here is arrested having done something wrong, he is presumed innocent until pronounced guilty. And if you have not exhausted all appellate processes, you still have a chance. And that's why we have members of parliament who have cases that already have been decided to be criminal.
Okay.
So we should think that with the advice of the legal team, something can come out of this that will take Kenya to the next level. Because what is important is not those that are happy that this has gone the way it has gone. Because we attach too many politics into very serious issues.
And yet it's the politicians that originated
I'm saying
this.
it's not only politicians, even Kenyans have participated in this process. When county assemblies, 26 out of 47, have done what it is that they did, those are representatives of the people. And when you look at Article 1 of the Constitution, supreme authority is vested on the people and is exercised by the people directly or through the elected leaders like TJ Kajwang.
And the judges agreed with that, said it's the sovereign power of the people.
And what really shocked me in that ruling, because I heard it when I was here, I cannot talk about what has happened in the last 5 hours. There's a place they said there are some clauses
that are unamendable.
That are unamendable for eternity.
And we'll continue that conversation.
We will be this way
forever.
Our children, our grandchildren, and the children of the next 500 years.
And we'll talk a little bit more.
That, I think, to me, and I think everyone agrees with me, those are things that need to be checked.
And
because if we find we have done something within 2010 Constitution that requires to change those clauses, I'm sure there should be a way to do those things.
Yeah, let's take it to lawyer Charles Kanjama, perhaps, who has been following this conversation. Thank you for making time for us. Again, the entire country taking in all of what has transpired in the last couple of hours, what these judges have rendered in their verdict and judgment this evening. Your highlight, what stood out for you, what you agree with perhaps or disagree with in this?
Sophia, of course I cannot agree with everything or disagree with everything. I listened to the judgment keenly. What stood out for me was that it was a resounding rejection of the BBI process. That the process was mired in illegality, in contrived use of constitutional processes to accomplish or to achieve unconstitutional aims. I think there was a very resounding rejection of the president's role in marshalling the BBI process through getting signatures of Kenyans even before they have read the bill, pressuring IBC to approve the signatures even before Kenyans had the opportunity to validate the signatures, getting the process through the county assemblies and parliament without even the possibility of any dissenting voices. And I think what the court was saying is that you need real public participation and engagement on an enterprise of this magnitude. And just to clarify on one point that has been said by Honorable Kabogo, what the court said when talking about eternity clauses, it used that phrase not to mean that those clauses can never be changed, but to mean that there is a higher threshold that must be met to change those clauses. And that higher threshold includes a constituent assembly similar to what happened at the Bomas Constitutional Conference. And even though this sounds really shocking, there is a precedent for this decision in a case that was decided around 2005, Njoya versus Attorney General, which declared some of the processes that related to the post-Bomas constitutional amendment, the Waki draft, as we used to call it, sorry, the Wako draft, as unconstitutional. So the court actually was relying on certain precedents when it reached those decisions, but ultimately I would say the underlying philosophical theme of this judgment is we cannot have a constitution that has been established through such a broad-based participation of the public, manipulated based on what happened in our past history, 40 years after independence, when we kept changing or amending the constitution at the behest or the whim of the political leaders of the day. So that was the major kind of like rejection by the judges. They were saying this is this is not something that we can countenance.
All right.
I think the second thing that struck me, and I'll be very brief on this, is that the judges felt that they needed to go beyond rejecting the process and some of the substantive proposals in the BBI bill to even condemning the President of the Republic of Kenya for having behaved in an unconstitutional manner and issuing a clear declaration that he has violated Chapter 6 of the Constitution, Article 73, which has to do with the duties of a public officer, and going ahead to say that the President is not immune from court cases where he has violated the Constitution, and going even further to say that the Attorney General cannot use public resources or his public office to defend the President in those kind of cases where the President has been sued in a personal capacity.
All right, Kanjama, we appreciate your time with us tonight here on Crossfire. And I want to pick up that point you made right there, the condemnation and rebuke directed at the President. And Honorable Khalwale, do you think when you hear that he failed to respect and uphold, safeguard the Constitution, is this the kind of stuff that's impeachable from where you sit?
You know, those are not just English words. Those are words that are chosen carefully to carry weight that would have consequences. One of the consequences is, as I suspect a litigious person is going to do, they are going to proceed to court. But the other alternative is, what are the other institutions of government going to do? Namely, National Assembly. If I was a senator, I would now be sitting waiting for a motion to come from the National Assembly recommending the impeachment of the President. But because of where we are, and because we do not want to raise temperatures beyond where they are likely to be driven by this ruling, going the impeachment route is not the way. The best way is to allow the President to search his conscience and then respect what the courts have said. He has a very bad history of refusing to obey court orders. We know that he has not appointed 41 judges. We know that he has not dissolved Parliament, despite being directed by the Chief Justice. He has a bad record. And this is why I'm appealing to his conscience that tuache maneno mengi, we drive the country forward. This decision is more momentous than even the nullification of his election in 2017. This is what I would like to say. I would like to, because it is sensitive, I would like to appeal to my brother Tom. Tom, don't go the route of lying to the public so that you get what you want. When you lie to the public that the biggest loser is devolution, surely the public knows that the take home in BBI on devolution was the increment to 35%. And you know, and you are a lawyer, that in the current setup, there is nothing stopping President Uhuru and you parliamentarians, nothing stopping you from giving counties even 40%, because the clause is very clear in the Constitution, not less than 15%. So as Governor Kabogo said, the things which can be given to people, let them be given instead of hiding in the Constitution. Lastly, Kajwang, why I'm being hard on you, it is because it is the same diplo-speak that was used under independence by the ruling class. They got patriots in the Mau Mau to bring independence, and when it was over, they brought in the culture of grabiosis. They grabbed all things that you know on record. And as soon as Kenyans started waking up to it, they told them, wait a minute, it is not the independence which is the problem. The problem is multipartisan. So we wasted a lot of time. Kenneth Matiba, James Orengo, Martin Shikuku, let me just finish this point. They wasted a lot of time. Multi-party came. And what did the ruling class do? They then went and held parties hostage so that political parties became private property.
All right.
No, let me finish.
Yes.
Let me finish. It's important. I'm driving an important point.
Correct.
So the political parties became private property. And then they came back to Wananchi and told Wananchi, wait a minute, the problem is not multipartism. We need a new constitution.
Yes.
So we brought the constitution of 2010. And after we gave the constitution of 2010, instead of implementing it, you are now coming to us with English, fat English from London, telling us that now the problem is not the constitution, the problem is BBI, let us go for a referendum.
All right. I want to bring two issues to you, and before I do that, a development we are getting in right now, coming in from the proceedings, still ongoing. Remember, the parties have got a chance to respond, and IEBC reacting to that they are unconstitutionally, they're not constituted properly, no quorum. So that brings into focus the question of the Bonchari by-elections, and can they go ahead to do that? So that's some of the developments going on right now. We'll keep you updated on the same. But I'll ask you this, TJ, because on one hand, the likes of your colleagues and you have been favored by the fate of Otiende, and as far as he's losing his position, the issues he was raising around the constitutionality of some elements that now the court, in essence, agreeing with that position, the likes of Orengo. What do you make? Does this vindicate them, at least to some extent? The deputy president as well. Remember, he kept saying this thing should be multiple choice. You cannot bundle it all as one bill. People should be able to make a choice and say, I like this, I don't like this. But the insistence was chukua yote, yes or no?
Well, Sophia, I won't let you go away with that favored
yes.
comment of yours, because it is also flavored with a lot of connotations. The two gentlemen have served in the National Assembly, and they know changes in committees is a small matter. It's an issue of an in-house decisions that are taken from time to time.
It's because of decisions he made, positions he took on this bill.
And everybody who is in the National Assembly, Sophie, comes with one CV. That is, he has been elected by people to be there, right? And so, when you are a legislator, that's all that you require to be able to do things that Kenyans expect you in that house. So this thing which the press have had about it, talk about it and hammer it every time, I think you are accentuating something which is not germane. What is germane is the content of the issues that we have. And I want to really weigh in on this. You see, Uhuru Kenyatta, and I had you as you were in the previous excerpt, Uhuru Kenyatta and Raila Odinga are Kenyans, right? They are Kenyans just in as much as one is the president and one is the former prime minister. And if a Kenyan is able to promote or to initiate popular initiative, I found, to that extent, the judges said something which I really have to reflect and absorb. Why would a Kenyan, who happens to be the president, not be able to initiate an amendment which you and I can do?
But he's not. I'm not the president.
No,
then any of us could be
presidency does not make him less of a Kenyan. I find that is an issue, in my view, that I think I would have to reflect how the judges, argued out and came to that type of decision. But you see, that we have to respect the courts of law. That was a 5-bench decision, a very strong one. I know those judges, some of them I know personally. Yeah. Many of them we were with school together, and I know their capacity.
May I ask you this as a lawyer, to that point, around the IEBC and what now they're raising? There are by-elections next week on Tuesday in Bonchari, Juja as well, several others in the past couple of months. That if in fact with the 3 that are in office, they did not have quorum and everything they did is unconstitutional, from where you sit, what does that then portend?
Well, that is the adversity. That's the problem we have here. And I think that was the point that my senior, Kamotho Eganjo, was addressing, that the judges overreached themselves. In fact, somebody called me as I was coming, and he said, have you heard of judicial activism? That was judicial activism. When you make decisions as though you are not part of this country. And knowing whether it is before you or not, these are issues which are live to be able. You see, judges are very fortunate. They can sit very honorably behind their gowns and garbs and make decisions, sweet decisions, and interpret. Some of us, our roles are a little different. We have to go to the terrain and give ideas and convince the people that those ideas are usable. And so it is one thing to interpret what I have done, but judges should also know how hard it is even to get that idea to be implanted in the people in the first place.
All right, before we come to you, Honorable Kabogo, a quick tweet here coming in from the Deputy President a few minutes ago. This is his reaction to that historical ruling there. There is God in heaven who loves Kenya immeasurably. May God's name be praised forever. Your reaction to that. Amen?
Hallelujah.
I mean, what the DP has said is what we say every Sunday, is what you say when you want to praise the name of God.
He's celebrating.
Because God, probably he is. But that does not change who God is.
Correct.
It is a daily thing. God is good all the time.
And all the time.
And for Kenya, God is good. I want to say, I do agree with what this gentleman is saying. I said it's not all lost. Number one, on the issue of IEBC, we need to tread carefully. Because if they have pronounced themselves to the effect that anything IEBC does is unconstitutional and illegal as of now, and that decision is not stayed, then it will be a waste of public resources for IEBC to conduct any business that requires them to have quorum. That's my take. On the issues that the bullfighter raised, I said earlier, I've said this before, that there are many changes that can be initiated at the level of the National Assembly, at the Constitution level, so that they get two-thirds and make those changes. But there's a misconception here that those who are proposing to change the Constitution to increase monies to counties to 35%.
Yes.
It says minimum 35. I mean minimum 15.
15.
And I remember in the first summit, we tried to request for more money when Bonnie Khalwale was senator for Kakamega. And what the Deputy President and the President then said was that, William, you seem to be fighting a lot for this. How much money did we disburse last year? We said the amount.
Yes.
What is that in percentage of what we were supposed to give? It worked out to about 29%. And he goes, then what are you fighting about? It is within. Right. It is not below. So we wanted to raise that bar to 35 so that any madman who comes into office and decides, no, these guys don't deserve this, they deserve 15 or 12, we would have safeguarded that position. So some of those things, it is true, they were meant to improve and to put a ceiling so that you cannot go below that ceiling. So we need to get popular initiative from these guys who are in the National Assembly. If this process does not go on, we still can make some amendment between now and the next election, which is 2022. To celebrate that now this is dead, that means that whoever is celebrating does not think there was anything in that proposal for Kenya per se. And it doesn't mean that those who are hurting, that everything was good. We are a nation that needs to move forward. We need each other. This divisive politics of everything, it's them versus us, them versus us. And most of these things move around our beliefs of who we follow in politics.
And to the
so most of the things that are mainly debated today, it's about what's going to happen in 2022. And that's why I say we need to move ourselves from positions of politicians to become leaders, people who think about Kenya in the next 20, 30 years, as opposed to people who just think about ni wakati wetu it is next election, what will happen?
Yes.
And if we can all start moving that way, then we will have a beautiful... Let me tell you, Sophie, Kenya will be there 2023. And Kenya will be there 2053 when some of us are gone. Kenya will still be there. And that is the driving thing that I would imagine that as Kenyans we should be looking at.
All right, let me bring in lawyer Kanjama Charles, I think, who's still with us. So the by-elections that are to be conducted next week may not happen following this verdict by the 5-judge bench that the Independent Electoral and Boundaries Commission has no quorum. So they were pleading with the judges to suspend that finding on the IEBC for at least 14 days. The IEBC lawyer, who's Eric Gumbo, argued that the electoral agency is now handicapped and the by-elections in Bonchari and Juja, slated for next week, may not happen. Your take on this?
Two things, Sophia. One, even if the High Court doesn't suspend that finding, the IEBC always has an opportunity of going to the Court of Appeal and seeking stay of that particular provision. And they can do so. That's the first thing. Number two, that finding of the constitutional bench is in relation to matters where IEBC has a choice. In other words, there is no constitutional timeline that is rigid that requires IEBC to act at a particular time. Where there are constitutional or rigid statutory timelines, like in the case of the by-elections, there is a doctrine that has been adopted by the Supreme Court that would be applicable, called the doctrine of necessity, that would allow cover to IEBC to act, to conduct the elections, and to defend the election outcome in the inevitable election petition that would be filed subsequently. So my view of the matter is that even if the decision stands as is without any stay, that should absolutely not interfere in IEBC conducting by-elections, which are governed by rigid statutory and constitutional timelines that require that vacant electoral seats are replaced within a certain period of 3 months.
All right, and finally, perhaps there were several directives, I think about 20 of them in this, so they can each be appealed separately, correct?
Generally, the people who appeal would appeal against all of them or all the ones that they do not like in one memorandum of appeal. But if the one that you don't like is only one finding, you appeal against that one finding. If you don't like 8, you'll select those 8 and appeal against those 8. So it is quite correct that you can pick and choose what you don't like and appeal against it.
All right, thank you, Kanjama. Honorable Khalwale, the DP celebrating, he is really saying, seeing this as much as he refused or declined to be cornered to mount a no campaign, he maintained their issues, he articulated the issues, but in this moment he is rejoicing.
And he's not alone. He's in good company, for the reason that if he was celebrating alone or against the people who are pushing the BBI, it would look selfish and self-serving. But this is a man from day one. He faced the country live and articulated 1, 2, 3 items that required not to be removed, that needed Kenyans to sit together on a round table of national brotherhood and build a consensus. He did that. He has repeatedly said the same, both in public and on his Twitter handle. So I'm not surprised that he's joining the rest of us in celebrating. What is more, in the intervening period, we have seen the culture of the African big man syndrome, whereby anything that President Uhuru says, anything that former Prime Minister Raila says is law. So this is a good reminder that yes, you are very big people, but God is also there. It's slightly bigger. And on this point, because my brother Tom has referred to me and Kabogo, yes, we are senior than you in parliamentary terms. I want to advise you, it is not as simple as that you got elected. In fact, being who I know you are, I expect that you are going to resign tomorrow as the chairman of JLAC because of the collective shame. Look, look, Honorable, look, if it was just you alone, we would say, well, take it. But this is a well thought out strategy that you have been using to intimidate Kenyan leaders. You started with Susan Kihiga, removed her, removed Kipchumba Murkomen, yes? Amolo Tiende, when he raised...
I think, Bonnie, you want us to go into a discussion that really is not part of what...
No.
You have made your point. You have made your point.
I think I'll ask this.
I don't want to be the advocate of TJ, but I think
Sophie, since I became the vice chair of JLAC,
hold on.
I've learned to be
The
patient.
floor is mine.
Hold on. Let's him execute.
This is why it is called crossfire.
I have learned to be.
Can you hold?
I have learned to be patient to absorb even the likes of the bullfighter.
Then let the punches
fight on.
Exactly.
Fight on.
I expect Governor Kabogo, that you appreciate you are on crossfire, and that you're going to be given time. You're going to be given time to respond to the issue I'm raising. It concerns me that, knowing that we have got a robust constitution that has got the Bill of Rights, where members of Parliament have the freedom of thought, the independence, and the freedom to express themselves, they are being treated the way we're treating them. It is even as recent as Senator Kangata, the senator from Murang'a. So, Kajwang, you are part of the cabal that is now reminding Kenyans that nothing changed with the new constitution. You will do as the prefect does. If the former prime minister is somebody's prefect, if the president is somebody's prefect, he is not the prefect for all of us.
I'll ask you this briefly as a follow-up on that. Are you surprised then that with all the issues that have been raised by the judges, that they'd been blindsided in terms of the legal capacity and minds in both the president's ranks and that of the former prime minister? Are you surprised that all of these issues that have been emerged in such a blind spot?
What is more surprising to me is that, given the access that the president and the former prime minister have to legal minds, why were they not advised on these things that have been so clearly articulated by the judges?
Yeah.
So when I see somebody like Kajwang, who also is a legal mind, reduce it to a simple issue of judicial activism. Kajwang, are you telling me that Judge Odunga is an activist? The same Odunga who gave you and I a favorable ruling when we went to him during the infamous Security Laws Amendment Bill. He gave us, and you and I, we celebrated. Why didn't you call him an activist at that time? Okay. We need to respect the institutions. A five-judge,
How long does he have?
Because you're...
A five-judge bench
briefly
is such a big constitution that I would rather I go by their decision than the decision of one lawyer.
A rebuttal.
Well, Sophia, I take no interest and no pride in being flamboyant about this issue. And I don't think that I choose not to play politics on this. And I will allow what the bullfighter has said go with the air that it's worth.
Don't you feel let down then? May I put a direct question to you? The former prime minister and the president being legal minds, and as far as those issues raised, unless you disagree with everything in totality.
No, well, this is why we have courts of laws. We will do things in the best interests. We will do things in good faith. And there is a judiciary that will interpret our actions. It is so easy. And I see no issue here that anybody should frown upon. And by the way, this is an initiative by some people. I told you that these are people who had the courage to do it. and to go to Kenyans and get signatures and get the county assemblies to vote them. Boni Khalwale and those people who have become Christians and preachers, they had also that opportunity. If they thought that there was something wrong with the Constitution, they did think that there was something wrong with the Constitution. Look, I don't mind people taking positions, but I am really offended when somebody prevaricates. He's neither hot or cold. You don't oppose, you don't accept. But when the chips are down, you come off the layers and say, thank God there is a God in this country. You know God when men have come home with results. You know, this is the kind of country we are in. And look, this is the problem we have because we have trained our constituents, the people of Kenya, to be thinking about personalities rather than issues. Here, let's talk about, he keeps on referring to names. The other fellow keeps on referring. Let us put the names aside and let us look at the issue. Now, if perchance things go the way they are, and you and I know that we said that there was 20% of this constitution which didn't sit properly. Now with the judgment of this court, I feel like we have 50% that is not, including those that I'm shocked today, you cannot change at all. Well, so, a time will come. I appreciate Charles. Yeah. Charles has given us an eye-opener, view there. But a time must come when the country must face itself and say, this is how we want to correct ourselves. Let us not compare ourselves with the West or with other people without our boundaries. Mm-hmm. Let us have a process which is suitable to us. Lawyers call it, sui generis. In other words, something which fits us. It took a long time to amend the American Constitution. Mm-hmm. It has taken even harder in other jurisdictions. Mm-hmm. But just because those people went through all those decades trying to get their things done, should not afford us this fearfulness of refusing to change things which we know are wrong and to know how to fix it. Mm. Talk about parliamentary initiative. Yes, there are things which we can change by parliamentary initiative. But the crux of the issues in this country are not parliamentary initiatives. Parliamentary initiatives are things which deal with day-to-day activities that don't touch the Bill of Rights, that don't touch organization of government. The things that we want fixed so that people will not go to war. My people of Ruaraka will not fight when the day comes, is when we set to get the governance structure working well.
All right, Honorable Kabogo.
I think one thing that we need to be clear here about is that the 5-bench judges' ruling was not anything in particular about the proposals. It is the process, it is the procedure.
Well, there was the proposal of constituencies and the limitation. It is how it was done.
They said if it was to be done, this is the way it should happen.
That IBC should do
it's a process. So let's not look at this judgment as a thing that has thrown every proposal that was in BBI as a nonsensical proposal. Mm-hmm. It is not all lost. When we stop looking at these things as a winner-loser and look at it from a wholesome position, that if things were not done through the right procedure, can it be redone? It will be done at some point in Kenya. Constitution change is not prohibited. It will be done. They have stated, as I was sitting here and listening, that this element of what was done is wrong. For example, what you've just said about unconstitutional quorum of IEBC.
Yes.
That is something that can be done.
The politicians left this issue pending for so long.
Let me finish.
Those vacancies have been there for so long.
Let me finish.
Yes.
I am not talking about who to blame. I am saying that that number is
be held accountable.
That number is the problem. There are many people who would have initiated the change to make sure that IEBC is constitutional.
But Governor, how did, as a country, we've sat for months on end with that problem?
That issue is not a 47 million action. We are 47 million Kenyans. We cannot all change that quorum. There are those that have that responsibility.
Exactly. And
so what I'm saying, my position is that I'm not saying that those judges have made a mistake. I am saying they've pointed out things that could have been done otherwise. Correct. So it is not every request that was in BBI that they haven't said anything. This is not possible. This is the only thing that surprised me is the element that said is for eternity. And Kajwang has, not Kajwang, Kajama has tried clarified, to, yes. I don't know whether we cannot hold his, that was his opinion.
He's a legal man.
I'm saying scholar. It has to be accepted all the way up to the Supreme Court that that is the position. So what am I saying? Is that this is not the end of Kenya. It is not. Kenya will move on. Can we initiate those changes if necessary to bring about change between now and whatever year?
May I ask you?
It is not pegged to 2022. That's my take.
May I ask you, you've talked about 2022, actually, that's a question, because there are those who tried to push, and many times even on this show, that the supporters of the Deputy President needed to take a no position, in essence, to make this a precursor, a pre-run to 2022.
So what you're saying now...
So what I'm asking is what
you just stated is that supporters of the DP are the proponents of no.
There are those
That's
who
what
wanted,
you have said.
Let me repeat.
And some of the things in here, I said myself, I don't agree with them.
I'm asking to the extent of the political question, not the ruling. The political question that those who are trying to corner and push them to say no, so that this becomes like a litmus test in essence. So they mount a no campaign.
A pre-22 election.
Exactly. So...
Well, some people would look at it that way. Others would look at it in a way that if you're cornered to do it and you get up to do it, you will lose the next election if you lose the referendum. So that also is a thought that many people have said.
All right.
But I'm saying these shenanigans don't help the country.
Okay. I want to put a direct question to you as you perhaps touch on that, because after the president, and you said this is bigger than the annulment of the president's election in 2017, and you saw his reaction after that happened. We will revisit a very visibly angry president. What do you foresee coming after this one? From the president, in your view, now that this is bigger?
Yes, but before I comment on that, there's this issue which has been raised twice by my colleagues on the issue of clauses that cannot be deemed to be amendable. I think, Tom, it is you who is going to educate us this evening. It is a principle of constitutionalism that there are certain essential clauses in a constitution which you cannot amend. The only time you can find yourself touching them is if you are changing the constitution, replacing it with another one. In this case, BBI is not about replacing the 2010 constitution. It is about amending it. Now, let me make my point. Kabogo, you said correctly that on 27th of August 2010, when we promulgated this constitution, we gave it to ourselves, our children, and the children of our children's children. Yeah? That being the case, then we must therefore realize that this is not our constitution. It's a constitution for eternity. Now, if you don't rise to the fact that all chapters in the Constitution do not have the same strength, you can end up completely destroying the Constitution, mutilating it until you have a new Constitution. Let me give you an example. The chapter on the Republic of Kenya, it defines the territory of Kenya. Are you telling me that you can get 1 million signatures which you get, for example, from the border communities? The Abaluya can choose to give you 1 million signatures for amending the constitution so that Luya land is no longer part of Kenya, it becomes Uganda. You would have gotten 1 million signatures. So that part on territory is not amendable. We don't expect at any stage for the territory of Kenya to change. Second example, Bill of Rights on religion. Are you telling me it is difficult to get 1 million signatures of Christians who will tell you that we don't want Islam in Kenya? you can get those. You'll get 1 million signatures. So that right becomes eternally unamendable because it is not imaginable that you could erase Islam from this country.
All right.
Let me give you the third example. Let me give you the third example. You'll respond, sir. Let my mind flow. Yeah? The chapter on the executive.
But sorry, you would have to give him time. I mean, you have
the
to
chapter on the executive.
time him. If you don't time him,
Okay,
Kajwang.
last
we
point.
will be here to
Kajwang.
spectate, and we did come to spectate.
Kajwang,
I'm coming to you
the
shortly.
chapter on the executive, it must be an eternity clause. Because what can stop the president in being ambitious the way President Uhuru has been, and then he gets 1 million signatures and says, we want to change the executive so that we no longer have the presidential system, but we have a monarchy. So the executive is for eternity.
Bonnie, you are doing very well on the first two issues.
I've finished.
Of our boundaries and the definition.
Religion.
You are doing very well up to that point. And I'm saying those are things that can be locked into our constitution, that the following things cannot be amended. And reasons thereof given.
Yes.
But if you look at some of the clauses we put in 2010,
yes.
For example, that this constitution cannot be challenged in a court of law.
Yes.
If you have such a bench of 5 judges, and there are things that are truly unconstitutional within the constitution, that violate even the Bill of Rights within the constitution, that are contradictory in nature,
like
one article to another. Things we used to say, you know? And why it was blocked, that it is not challengeable, is so that it is not amended many times and being taken to court that this is unconstitutional. Some of these things we need to look at afresh. The way Kenya was 20 years ago is not the way it's going to be in the next 20 years.
All right. So
what I'm saying is, it is true, and Kajama has said, there is a process of changing those things that are said to be changeable, but the process is what it is that they were talking about. So I do concur that, of course, there are many things that we would not want to touch, looking at Kenya 100 years from now. But I'm saying again and again, it is not lost. There are many ways of getting this to the next level if we detach it from politics of elections. Because that is where we get it wrong as Kenyans. We always want to peg changes between this is for these people, this is for these people. For example, this is for Raila Uhuru, this is for Ruto and others. Those things are the ones that we should be worried about as the leaders of today.
Yeah, and I'll bring this to you, Kajwang, because it was interesting. The president, throughout this BBI process, described the constitutional, the move to amend, the push to amend the constitution as a constitutional moment. Many of his speeches were very elaborate about trying to call on Kenyans to get on board and support this. But listening to the judges earlier, some of the words they use are schemes, you know, to sort of like twist and turn to do things that should not happen in that process, that there was stealth. It was very interesting because it sounded like some plot really in front of our faces. And, you know, also Raila saying no one can stop reggae until 5 Judge Ben said,
no one can stop reggae.
There's a question.
If you stop reggae, we will just go rumba.
There's a question Sophia asked.
That is what I want to...
And it was answered by
that is what I,
Dr. Khalwale.
That's why I was coming
to the effect, not now, earlier on, a while ago, about what it is they said about the president being sued.
At a personal level.
And we did not, I did not participate to answer that question. But what my view is on that is that the judges are telling those who are litigants, guys, here, there is a road.
Come.
Go and do it.
Come on, come on.
You know, go and do it.
All right.
I would imagine that...
Let me put all this into the question. The original question was the revisit question, if I remember the question.
He's not answered actually my question, but I'll bring it. I'll bring it back.
He was not happy that I was talking,
too much.
so I gave him space.
But now I can put it together.
Yes. Land.
I had this ruling, and I thought, oh my God, it is not the president revisiting. It is the court revisiting on the president. I thought I saw a lot of sentences which were very surprising. Yeah. For example, the schemes, the selections of words and the adjectives, the question of whether or not one can sue the president is something which has been litigated before. But on things which he does in good faith and which his office allows him to do, you cannot, I mean, there is immunity in the presidency.
Correct, and they said that.
Yes, but thinking about it, when you get a court which I would want to know exactly what Boni's clients or Boni's team took to court, because I feel that the judges went beyond what they were asked to deliberate on. And that's why you are finding sentences which are going towards to affect Bonchari. Then you are going to get information that are beyond exactly the confines of the BBI. But that said, our issue is not quite about the fact that reggae is stopped. We know the heart of Kenya. We know that the Kenyan is desirous of fixing his issues. Mm-hmm. That goes without saying. And it is important that we have men and women who are in the business of bringing ideas like my governor, right, to the table and be brutal about it, open about it. Wrong or not wrong is not the question, but there you have ideas on the table which Kenyans can choose from. And so, in my view, I think that the promoters of the bill did a good job, have done a good job to suggest these issues, and the people that came forward, the 1 million or so people who signed those documents, the county assemblies that passed, the National Assembly and the Senate Parliament, we just the other day voted the document. We have done our bit that is expected of us. The judiciary is also doing its bit, I agree. But it is in this commonality that therefore we find how we can fix our issues as Kenyans. Mm-hmm. Yes, Boni, I agree with you. And this is the only area that I agree with. No, I don't agree with you in so many other issues. But one of them is this. That, of course, there are those parts of the Constitution that you cannot change. I'll give you one more example.
Yes.
One more example is sovereignty of the people.
Exactly, and the supremacy of the Constitution.
No. It's not the supremacy of the Constitution. What we have in Kenya, Boni, when I talk law, give me time. You see? It is not supremacy of the Constitution. In Kenya, what we have right now is the supremacy of the people. Sovereignty of the people. The people is above the Constitution, literally. And so, if were we to change that system and say now the people are subservient, that will require a national convention because it will be like a new document. And so, yes, we agree, but that does not take us away from analyzing where we are right now as Kenyans.
But are you not misleading viewers, TJ Kajwang, when you said that, you know, the president is also a person or people, and the people is the president, in terms of the indictment and condemnation by the judges, saying that this was a president initiative, not the people's?
No, I don't agree. I don't agree with the judges at all.
No, but I want to say that the president, in essence, in your interpretation, is just like any other person, that it was still a popular initiative.
All I'm not saying, Sophie, Uhuru Kenyatta is also a Kenyan, he's a human being. That is all I'm saying. He may be the president of this country. He may be the person who wields the presidency.
The president.
Yes, he is. I know he is.
Holding that office in trust.
I know. He is holding in trust. But I'm saying he, too, is a Kenyan.
But you cannot then say, as a Kenyan and he's the president, can start a popular initiative.
So the question
is, are you saying that a Kenyan cannot
when does he stop being a Kenyan because he's president?
Can you stop the president from exercising his constitutional rights? Doesn't he have rights to exercise? Can't he make proposals in some way?
Proposals he can.
Yes,
my brother Kajwang.
So just wait a minute. Just a minute. So President Uhuru, Raila Amolo Odinga are human beings. That is now, let's talk about human beings. They are human beings. These human beings have rights. And one of those rights is to propose legislative amendments if they wish.
They did not only propose, they went full tangent, full throttle on that process, contrary to, as the judges said, as it's envisioned and captured in the...
I must be honest enough to say that there could be a few things which may have not been done correctly.
Good.
But yes, I say so because, you see, now we are looking at things backwards. Yes. We are looking at things when they have been analyzed by a court. But that is why courts happen to be there.
So like that one is one?
To do what? For a president to
begin a popular initiative.
I think if you are listening to the judgment there, I was sitting here.
I was looking to hear.
The judge, I think it was Judge Nguki.
Yes.
He said this is our Njiko.
It's supposed to be.
It is our Njiko process. It should be. It should have people's initiative.
Correct.
It should have been. It should have had.
Initiated.
It should have had public participation. So that does not say that the president cannot throw the word.
Yes.
It can go to Wanjiko. It can go from Boni Khalwale, Kabogo as a president. Not only Kenyatta, even as the deputy president. Yeah. And it will go to Wanjiko, it will become a national debate, and it will take the people's
well, that's
approach.
Contrary to what Dave said, but
that's what the judge said. I was listening.
I'm coming to you, and you'll give us the last one because our time is actually up. But I'm keen to hear
so
so soon when it's so good. I know, right? But you said something that I'm still stuck there. That in hindsight, now you said that there are things that could have gone wrong. So 2 or 3 that now you sit after hearing that you now think
well, I'm just saying that when you analyze a process, now that a judiciary analyzes a process, it is so easy to find things which could have been done better.
Like?
That is very easy.
Like what?
For example, there is this discussion about the constituencies.
Okay, the delimitation.
Right? No. Mm-hmm. The delimitation.
Yeah, one.
Yeah. No, just don't count them that way. Let me explain why that is what it is. Yes. You see, the Nini is good. The principle is good. What Governor Kabogo is saying, we want to open up the base down here so that there is more funding which is flowing to the constituencies.
All right.
In Germany, we have a legislature, the Bundestag is 560 members,
right,
and they operate.
Honorable.
The only issue, probably, that these judges are taking issue with is the confluence between the mandate of the IEBC in delimitation.
And the bill.
Yes, and this.
Allow me to, and he would protest, but he has not. You have been on the floor for quite some time. So, as you wind up, the question I asked earlier, that you thought this is bigger than the presidential election annulment, and we saw the president, again, visibly angry. We will revisit. And some have interpreted some actions since then as revisit. So when you see this being worse or bigger, what do you foresee in the next coming days from the president?
I am worried. Because every time that the president has spoken on the issue of BBI, he speaks with a lot of anger. So I imagine that going forward, that anger might increase. I hope that the people who are close to him, who give him wise counsel, will tell him that this is not about him. It's about Kenya. Look, for the High Court, 5-judge bench, to indict him the way they did, they were basing it on the evidence that was placed before them by the petitioners. The president, Kajwang, went and formed a committee and started expending public funds without you, members of parliament, appropriating that money through budget. He was acting beyond his powers. The president, my brother, went on, and when he wanted to please MCS, he gave them motor vehicles worth 2 million, not found in any budget. The president was acting beyond himself, Kajwang. I don't want you just to be angry on those things, but you must realize that why I'm saying it is bigger than when his election was reversed, that was about how he was elected. But this now is speaking to how a president should or should not govern. It's bigger. In fact, it finds itself where Americans found themselves a few months ago, when they were thinking that President Donald Trump was not governing properly.
All right.
President Uhuru is not governing properly. And as if it's not enough, why I think this was very good,
yes,
a wake-up call, is because Uhuru has refused to appoint 41 judges. And yet the constitution is clear that he must appoint those 41 people. So this wake-up call should make him, again, rethink and realize that before next year, awe mtu wa Mungu.
My parting shot is, in this ruling, you will find many things.
Yes, sir.
You will find that for them to arrive at the final decision of this is unconstitutional, most of those things, besides what Bonnie has said about the president's actions or inactions, there are many things about institutions. One being the IEBC as an institution. Many things that are very key in the decision of the 5 bench was how the signatures were supposed to be approved.
Yes.
That was one key issue they spent about half an hour on. The other issue of composition of the IEBC commissioners. Those are things that would have been put in place before the process started.
Correct.
Yes.
And there are many others that relate to executive in terms of the president's or people's participation.
Correct.
That is something that we would have done and achieved these signatures, even having taken it to the people.
Okay.
So we should not just look at this as a win for Bonnie Khalwale and his team, or loss for Raila Odinga and his team. If we look at it as a learning situation,
yes,
we will be able to do this because the constitution will be amended by those it will be affecting in future years.
Well said.
So really, I am not celebrating, neither am I crying. I'm only worried
You're learning.
I'm only worried that I expected in the next budget, and I hope that we shall be able to do it at Parliament and set a precedent that we can change money going and where it is going.
Okay.
The other issue is,
our time is
the
up.
last one.
30 seconds.
The other issue is,
Please.
Wanuna,
Government,
that is the 3 arms, serve people. The main thing here is citizens.
Correct.
The people. It is not land, ngamia, and those things. You understand? We need to start looking at how our constitution can be people-centered.
All right.
You know,
well said. Well said.
Nairobi has a population of 4 million in the morning.
Yes.
And those people are supposed to be served, Bonnie, from Nairobi.
True.
You understand?
Yes.
So we are losing that by just thinking about, oh, winner, loser. It is not going to be like that forever.
All right. Thank you very much. Honorable Kabogo, Honorable Khalwale, Honorable TJ Kajwang. You have looked at Thank you very much, gentlemen, for joining us. So much to discuss.
Are you a loser already?
I am a moderator of the conversations, not only today, but in the days ahead. And these are truly times... you're all looking at me, waiting for an answer. But there's something funny, though, as we wind up. Moses Kuria has tweeted on a light note.
Moses Kuria?
Yes, has posted, I think, on Facebook. Kidogo tu, Usikia Murathe saying, Jubilee Disciplinary Committee will summon the 5 judges latest Tuesday.
I think you got it spot on.
Because, as you know. Anyway, that was on a light note. Thank you, gentlemen.
That's Khalwale's friend. Yeah.
Thank you for watching
We're in the trenches together.
Crossfire tonight on behalf of the entire team. And it's a great team behind the scenes that made the show possible. We are grateful for your company. I'm Sophia Wanuna. Be blessed and good night.